dignitaries on and off the dais, learned seniors, and my dear colleagues. It is my distinct honor to welcome you all to this auspicious celebration of Young Lawyers Day. This event is proudly organized by the Adhivakta Parishad Odisha, Orissa High Court Unit in collaboration with the Orissa High Court Bar Association. Today, we gather not just to celebrate the legal profession, but to ignite the spark of excellence in the next generation of legal minds. Our theme for today's deliberation is advocacy, courage, craft, and contention. 4 pillars that define a successful journey at the bar. We celebrate Young Lawyers Day by reflecting on the ideals of Swami Vivekananda. Swamiji believed that the young peoples are the powerhouse of the nation. He famously said, "Strength is life, weakness is death." Let us now commence the formal proceedings. I would like to respectfully invite our esteemed guests to occupy the dais. Our Chief Guest, Honorable Mr. Justice Dixit, Krishna, Shripad, Shri, Senior Advocate, President of the High Court Bar Association, Parishad, Senior Advocate, President of Adhivakta Parishad, Orissa High Court Unit, Abhijit, Secretary, Orissa High Court Bar Association, and Jateshwar Naik, Secretary of Orissa High Court Unit. I also request to the dignitaries to kindly step forward for the offerings of floral tributes to the portrait of Bharat Mata and Swami Vivekananda for making the auspicious beginning of our event. Our colleagues to present a flower bouquet to our chief guest, Honorable Mr. Justice Dixit, Krishna, Shripad, and also to our President, Shri Mishra. Formally welcome this august gathering and provide a deeper insight into the vision of the Adhivakta Parishad. I would like to invite Mr. Parishad, Senior Advocate, President of Adhivakta Parishad, to the podium.
Good evening, dear friends. Honorable Justice Dixit, my learned senior, Mr. Mishra, President, High Court Bar Association, Mr. Prasad, Secretary, Jatat Babu, if I am permitted to call him a dear friend, and all of you to this meeting, which will be addressed by our Honorable Chief Justice Dixit, relating to advocacy and courage, craft, and contentions. So courage, craft, and contention, in my humble submission, would be all engrafted in the art of advocacy. There are much more to hear from Justice Dixit, who will give it light. And as we have all agreed that we will be giving him, His Lordship, the maximum time and the podium to him at the earliest, so that we will have the pleasure of hearing His Lordship to our heart's contention. I once again welcome all of you for this good and deliberation this evening. Thank you very much, and for the rest of the program.
Thank you, sir, for your kind words. We are now moving to the highlight of this evening. We are privileged to have amongst us a legal luminary whose wisdom is a guideline for all of us. I respectfully request our chief guest, Honorable Mr. Justice Dixit Krishna Shripad, to deliver his address and enlighten us on today's theme: advocacy, courage, craft, and control.
Dignitaries on the dais and my beloved friends. Where from I have to begin, I do not know. I have to begin after offering my tributes to Bharat Mata. She is Mata to one and all. If she survives, we survive. If she does not, we will not. And one of the great sons of Bharat Mata, Swami Vivekananda, used to say, Dhairyam sarvatra sadhanam. Without the dhairya, courage, there is no virtue at all. Courage is important. Therefore, courage, craft, and contention. Without courage, nothing happens. I have to demonstrate this. On 12th of May 1975, Justice Jagmohan Lal Sinha of Allahabad High Court handed judgment in Rajanarayan versus Indira Nehru Gandhi, and held the election of Indira Nehru Gandhi was marred by corrupt electoral practice. I am borrowing the words of the judgment. During those times, emergency was yet to come, not yet claimed. And Palkiwala argued the matter in appeal under the provisions of Representation of People Act 1951, where the High Court, in an election petition, enters an order that is appealable under the provisions of 1951 Act. Palkiwala argued during summon, and it was before the bench of single judge, Justice Krishna, and secured an interim protection subject to certain conditions, that she shall not vote in the parliament. She can sit in the parliament, but shall not vote. That was the kind of interim. She would continue as the Prime Minister, because country without a Prime Minister will be difficult, a difficult thing to comprehend. That was the kind of interim order. Rendering such a judgment during the days of euphoria of a political party was a great thing. We were told by our professors, because we were children at that time, they said, Justice Jagmohan Lal Sinha gave dictation to his stenographer one particular judgment, but wrote by hand another judgment. That's how he had set aside the election of Indira Nehru Gandhi. The kind of courage which he had, which a judge should have, is really a matter of appreciation. Matter was argued and a stay was obtained. And Pakiwala learned that Indira Gandhi was going to impose emergency. She penned a letter. My dear Indira, do not clamp emergency. And Indira Gandhi clamped emergency during the night of 26 June 1975. You all know what havoc was played with the lives of citizens. You have read that judgment, ADM Jabalpur versus Shivkant Shukla. Anybody could be arrested, assigning any reason, without assigning any reason to anyone, and can be detained for any length of period. Britishers did not have such legislations. Defense of India rules, MISA, Maintenance of Internal Security Act. And people used to say it is Maintenance of Indira Security Act. So many people were jailed. So many political leaders were jailed. Advani, Madhulime, Vajpayee, H.D. Devegowda, I.K. Gujral. So many political leaders were arrested. And great petitions were filed, which I'll come to later. Palkiwala sent the file back, saying, there is absolutely no reason for you to clamp the emergency, but you have clamped one. I requested you, but my request fell on the deaf ears. Therefore, I will not argue your matter. He returned the brief. See the courage of the person, the courage of the lawyer. He returned the brief. And Justice Krishna Iyer, in his Off the Bench, many books he has written, a great judge of the Supreme Court, who has made so many records in respect of many aspects. He writes, there used to be threat to Palkiwala. There used to be a police van parked in front of Tata House, wherein office of Palkiwala was located, only to threaten him that you are likely to be arrested. But he did not care. This is a case of courage. There was one judge, village munsif, village magistrate, called Rama Shastri Prabhune, whose reference you will find in Maratha history of Peshwas, Bajirao Peshwa, which Justice Rama Joyce mentions in his Legal and Constitutional History of India, 2 volumes, published by Indian Law Institute. He used to go for walk after rising from the court in the evening. One day when he was going, the sun was setting, and he saw a lean woman with a lean child and halted. He asked her, why, what has happened to you? You appear to be very lean, and your child is also lean. You do not appear to be healthy. See the concern of the judge. He never said, my court hours are over. After that, what all happens is not my concern. He was a human being with heart at the right place. Lady said, Judge Saab, I have not received any money from my husband, who is fighting war at the frontiers of the nation. Then judge issued summons to the husband, to the soldier. Soldier came and said, our military general has not given any salary to any of us, and therefore I could not send money to my wife and baby. Why? Then he issued summons to the military general. General appeared and told, I too have not received any salary because battle is going on. There is tough time for the state, and Peshwa has not released any salary to any of the Faujis. Then this village magistrate issued summons to the Peshwa. Peshwa is the king. In our old constitutional law, king is incarnate manifestation of the state. Rajaha pratyaksha devataha. Raja is pratyaksha devata. Who is this? This puny judge issuing summons to me. And summons was not honored. This judge issued an arrest warrant, as some of the judges of this court would do when orders are not complied with. Peshwa did not respond. See the courage of a magistrate of third class, village magistrate. We had third class magistrate till 1960s in UP. Judicial magistrate third class. Then it conveyed something else, and therefore rules were amended, and they said magistrate first class, magistrate second class. He was below the third class magistrate. He issues arrest warrant against the king. That is the courage. Of course, king did not obey. And the Bhattas, the Raja Bhattas came and reported to the king, the judge, you are not supposed to issue any order, warrant, summons, etc. against the crown. Otherwise, you will be committing contempt of the crown. What the judge did? Judge said, this is Adharma Bhumi, a land of irreligion, a land sans virtues. Raja is not Raja when he does not conduct himself righteously. Such a Raja was beheaded in England by Oliver Cromwell. He beheaded the king because king did not do his job. In English history you will find that, the parliamentary history of England. But this is a poor magistrate. He could not do anything except registering his protest. How he protested? In our Dharma Shastras, which are part of ancient constitutional law, they say, where king does not do his job, it is your duty to oppose him. It is your duty to oppose him. And if you are not capable of opposing, you should not see the sunset of the day in that kingdom. He left that kingdom with wife and a child, came back to Janpur, near Janwar, near Belgaum in Karnataka, and lived like a hermit till he passed away. See the courage. Fali Nariman was the Solicitor General of India during the emergency. He was dead against clamping of emergency. He refused to argue many matters where the union government had committed wrong and decisions were not sustainable. And in protest, he resigned the post. See the courage, true courage. That kind of courage is essential. Otherwise, all your virtues will stand suspended. Very good person, but he cannot raise his voice at all when injustice happens. What we should do with such people? Such people are many nowadays. Number should be reduced. Without courage, nothing happens. Courage of Chanakya, who fought against Navanandas and brought Gupta dynasty, Maurya dynasty. Who was that Chandragupta Maurya? A person belonging to the community which does hair cutting. What you call in Orissa, I do not know, for barbers. A person belonging to barbers community. He told Navanandas, I will ensure that your family is rooted out. A man with a small pigtail, who did not have much to eat, a lean personality with loin cloth. He raises his voice and raises his hand, fights against Navanandas and roots them out, establishes this dynasty, Maurya dynasty, which we will read. Maurya was not Kshatriya. Chandragupta Maurya was from the barbers community, or at least he was a shepherd. He was a shepherd. There is such literature, there is such historical document to vouch it. And he was made the Raja of that particular kingdom. See the courage. What is an amount of courage? Little we shall come to the life of Gandhi. In Gandhi's, the story of my experiments with truth, written in Gujarati, but translated into English by Mahadev Desai. He writes, it's there in Law and Lawyers also. Mahatma Gandhi was engaged to argue a criminal appeal against conviction under section 302, and he stood up. All lawyers were around. Judge appeared to be ferocious, but I am not. And Mahatma Gandhi fell down. He writes, after I stood up, my head started reeling. My heart sank into my boots. I fell down. When I regained my consciousness, I was in a hospital in Bombay. Then came, he only says that. I am only saying what has been written in that book. It is Mahatma's version. Then Vallabhbhai Patel took up that case, charged 30 rupees and succeeded in the criminal appeal, got the conviction and sentence set aside. So just I am saying, see the courage, see the cowardice. Cowardice is a dangerous thing. Then the Mahatma grows as a Mahatma, and Tagore gives him the title of Mahatma, blessed soul, great soul. You have seen the role of Edinburgh in the Gandhi film. When Salt March was launched by Gandhi, the British police, Indian police, they started beating all persons in the march, Salt March. And a particular police had wet the fist of Mahatma. Mahatma said, the fist may break, but it will not yield the salt. That is the courage. Unless one has courage, it is very difficult for one to enjoy life, enjoy profession, doing good things. Therefore, in our Vedic literature, there is one statement, Veera Bhogya Vasundhara. Vasundhara is earth. Who will enjoy the earth. One who is Veera, who has courage, who has no elements of cowardice. He alone enjoys whatever he does. Then courage is what? Conviction. Your conviction is the mother of your courage. You should have conviction. Soli Sorabji, the former Attorney General for India, he had launched an agitation when Justice Krishna Iyer of Kerala High Court was elevated to the Supreme Court. He opposed elevation, saying that a hardcore communist, if he comes to the Supreme Court as a judge, who will lay down law for the country under Article 141 of the Constitution, he will implement not the Constitution, but he will implement Das Kapital by Karl Marx and Engels. That is how he was opposed. And he stood steadfast. Without mincing words, he told the powers of the days be that I will not appear before him. For quite some time he did not appear. Thereafter, he was convinced that though Krishna Iyer is a hardcore communist, his communist ideology are not reflected in the judgment, and Justice Krishna Iyer will go according to the letter and spirit of the Constitution. He went with the same people, offered apology. We are wrong in opposing your elevation. We are sorry. And he offered tribute to Krishna Iyer in the subsequent days. So when we are right, we are right. When we are wrong, we are wrong. And in confessing our wrong, there should be conviction. There should be courage also. Without conviction, nothing will happen. Because courage will not take birth at all. It is from the courage, the conviction, the courage takes birth. Then we have craft. Craft is also very important. Our Vedic literature says, Asato mam jyotirgamaya, tamaso mam, asato mam sadgamaya, tamaso mam jyotirgamaya. From asat to sat. In Sanskrit, sat means eternal, which does not wither away. From that, from mortality to immortality. That is not all. From Satya to Saundarya. Our march is from truth to beauty. Therefore, what all we do, be it a petition under the Cattle Trespass Act, be it a petition under the Orissa Land Reforms Act, or such other small legislations of less significance, it should be done craftfully. We will draft the petition 100 pages, and we will draft our judgment 700 odd pages. Keswananda. Perhaps no judgment has exceeded that level now. Anyway, that is the benchmark. The strength of the bench and the number of pages of that judgment also. Judgment itself was like that, which Upendra Bakshi said, Keswananda Bharati would be the future constitution of the country. We understand that. But one thing I should tell you. R.C. Cooper versus Union of India, relating to bank nationalization, 1970 Supreme Court. was drafted by Palkiwala within 3 hours. It was so precise. Not even a word could be added to the proceedings, nor a word be deleted therefrom. He gave dictation sitting in a car for 3 hours. Such a short write-up. Craft is very important. Without craft, our views, the things which we write on the paper, we will be spending barrels of ink, tons of paper, everything we want to say remaining unsaid. Therefore, craft also is very, very important. Without craft, nothing happens. This craft may be in pleadings or in your submissions, in your arguments. A lawyer was arguing an appeal against conviction under the provisions of Section 13, etc. of the 1980 Prevention of Corruption Act. It was a police officer who was convicted for bribery. And judges were, the bench of 2 judges was very tough bench it was. Very tough bench. I was an eyewitness to that. The lawyer argued, judges said there is nothing, as often I will say. And the lawyer went back, saying that, my lord, I will not be able to do justice to my client. For my incapacity, why the litigant should suffer. Give a day or 2, he will engage some other lawyer who will come and argue before him. 1 week was granted. New lawyer came, Anil B. Diwan, who had argued that famous pension matter, which our Mohanty Ji, they will be knowing. Which is that? 1980, D.S. Nakara. D.S. Nakara versus Union of India. He came and said, my lords, even an honest honeysucker will lick his fingers, says Shakespeare. The first sentence. My lords, even an honest honeysucker will lick his fingers after he gives back that honey, the pot of honey, to his master. Judges said, there is something. This police officer is meant to guard, but what happened with the honeysucker happened with my client. See the way, how the submission is made, how the fertility of mind of the judges is ensured before sowing the seeds. So craft is necessary. In one case, argument was, the contract was wholly one-sided, and therefore under the provisions of the Specific Relief Act, the court has discretion not to grant decree of specific performance. He said, my lord, this sale agreement to sell, the contract to sell a piece of land is wholly one-sided. Kindly see, my lord, it is written only on the 1 page of the paper, the remaining page being blank. See the way it is said. He shows to the court the draft, and it is written on 1 page. It is Dvandvartha. It is one-sided, means physically it is written on 1 page of the paper. It is one-sided in the jurisprudential sense. These senses by nature of man amalgamate, and they may put you to trouble or put you to advantage also. Your lawyer's skill will decide whether you can derive the honey from this or you suffer. Therefore, craft is also important. During my initial days of the bar, I was reading Broom's legal magazines. Some thousands of magazines have been put in one book called Broom's Legal Magazine. So many magazines. Small example I will give you. There is one magazine called Nocitur e Socis. The meaning of a word in a statute will take color from the other words in whose company that word appears. A, B, C, D. There is no etc. There is another magazine that is Aegistum Generis. From the generalia being the species, genus, the species will take birth from that. Which aspect is discussed by the apex court in University of Madras versus Shantabai. Of course, main decision is reversed in Ujjambai versus State of UP is another thing. The doctrine as such, the maxim as such have been discussed. I had prepared a small note on that. The difference between Nocitur aesis and Aegistum generis. Aegistum generis is the genus speaks and the species are not exhausted. For example, go to Katak market, Bakshi Bazaar, get vegetables like tomato, beans, beetroot, etc. That etc. will not certainly include a pack of cigarettes because it has nothing to do with the genus. That is Aegistum generis. I wrote some 20 pages on this to make the point and went to my professor. I needed some appreciation. He said, have you read Broom's legal maxims? I said, no. Please read it. I appreciate that you have done very good thing. But at least go and see that. I saw. I was a bit hurt also. I saw, and to my dismay, Broom had said about both the maxims within 1.5 pages. 1.5 pages. See the craft. Summoned jurisprudence, especially 6th edition, 10th edition by Glanville Williams, 12th edition by Fitzgerald. See the concept. All legal concepts have been discussed. What is property? What is person? What is evidence? What is question of fact? What is question of law? What is the significance of law of limitation? What is possession? What is ownership? What is occupation? The difference between possession and occupation. The right to alienate. The bundle of rights, that's the ownership. So beautifully it is written. My professor used to tell me, do not read earlier editions of Salmon. Read 10th and 12th editions. One by Glanville Williams and another by Fitzgerald. That will make everything. Therefore, courage, craft, and contention. Contention may be in the House of Parliament. There was a proposal to introduce a bill for implementation of Hindi language as the national language. And after few persons spoke, Vajpayee spoke in the parliament. Earlier, all they opposed imposition of Hindi, saying that it is undesirable imposition. It's a linguistic barbarism. Some Dravidian MPs had said like that. It is available in so many parliamentary debates. Vajpayee spoke. It was so beautiful. The Dravidian leaders went and told Vajpayee, we have no objection for imposition of Hindi. So, you should be proficient in your language. If your language is not good, Bertrand Russell writes, what is said, it said is not what is meant. What needs to be done will remain undone or misdone. Therefore, these skills of advocacy, these are three things. There are many things which we can go on speaking, but you are tired. If you are not, I am. With this, I thank one and all. I should say one thing to you, that the quality of bar since last few months is enormously escalated, enormously improved. It's a great thing. I love this bar. I really love this bar. I love that bar too.
Thank you, sir, for your illuminating words. As we have learned, advocacy is also the craft and contention. We now open the floor for if
I think our younger generation is a little bit apprehensive. As the topic goes, like the Young Advocates Day, and the advocacy, courage, craft, and contention. So definitely the advocacy will come from our seniors' office that we learn throughout the day, seeing them arguing, the craft and the contention. But so when it comes to courage, there is always a misconception or a conception that the first generation lawyers, they have the courage to argue before the court, and the second generation or the person without any background, they have little bit lack of courage. So how do you bridge this gap, sir?
Courage is an attribute of personality. There may be an old lawyer, very timid. There may be a young lawyer, very courageous. It has nothing to do the youthfulness of the lawyer or his old age. Courage, Russell writes, Bertrand Russell, very often I read his books. He writes, courage can be acquired also. Palkiwala was a young lawyer. If you read that famous book, Law, Life and Other Things by Settleward, one day when Palkiwala was arguing, Koka Subbara was saying, sit down, sit down. Then Palkiwala complained to Settleward, then the first Attorney General for India, saying that this judge is not permitting me to argue at all. Such things happen in life. In any human institutions, these things happen, but they should not discourage. If we encourage the youngsters, they start arguing. Sometimes there will be some of the arguable pitfall in that, but we should encourage the bar because our judges come from the bar. They do not come from the heaven. They do not come from the Jagannath temple also. All they have to come from the bar. Unless the bar quality is improved, how are you going to bring good judges to this institution? That you can keep in view. Courage can be acquired also. Mahatma Gandhi, who could not stand up, fell down, and says in his book, my heart sank into my boots and head started reeling. By the time I regained consciousness, I was in a hospital. He was so timid. But by his continuous practice, he acquired courage. That is possible. Palkiwala was the first generation lawyer. Sirwai, you are the first generation lawyer. Many great lawyers were first generation lawyers. All they were first generation lawyers. Khanna, who gave golden descent in ADM Jabalpur versus Shivkant Shukla, who gave the basic structure, who accepted basic structure theory argument in Keswananda Bharati versus State of Kerala. 6 this side, 6 that side, he struck the balance. He was a first generation lawyer.
Thank you, sir. Thank you.
Sir, I have another question.
Come this side so that I will see.
My Lord, Justice,
Yeah.
today's seminar shall the
Straight question.
My Lord, law is the real profession of all over all the professions. But this is the lawyer when join the profession, young lawyer, he come with courage. Unless he can't practice in properly in the court. Then what are the crafts, the ways, process to how to accumulate the crafts, the young lawyers when the practicing in the court? Then how he maintain their crafts way, the ways.
A few days back, I saw interview of Steve Jobs. A question was asked as to how to perform well in the workplace. He said hard work. Next one, he said hard work. The third one, he repeated the same thing. There is no substitute for the hard work. You should love the library and books, not just cleaning them and keeping them in the shelf very beautifully. You should turn the pages. Enjoy every sentence. Make it a point to read at least 10 pages a day. 10 pages a day, 5 pages a day, 1 English poem, 1 Oriya poem, 1 Hindi poem, if possible, 1 Sanskrit literature. A question was put to Beethoven, the great musician. Beethoven had composed music for French Revolution. He was asked, Tata, Grandpa, how is that God has given you such a wonderful voice? Beethoven told that little girl, oh my darling, if you work 13 hours a day for 40 years, God will give that gift to you also. 13 hours talim for 40 years. Naturally, God will give that gift to anybody. There was a lawyer in the Irish court, very old lawyer. Because of extreme cold, if you go to UK and such other European countries, especially during winter, all courts are closed courts, no open court at all, Karsab. All they are closed. Yeah, during particular season. And judge, that lawyer who was supposed to argue in counsel, fell unconscious. Everybody was trying to make him regain consciousness, but failed. His junior came, who had a little away for sipping red wine or something like that. He came running to his senior and said, what has happened? The doctor said, we could not revive him. He is very old. Because of extreme cold, he has fallen unconscious. Oh, that's all. Do we have an old library here? Yes, we have. We went to old library, brought a old law book, and held it to the nostrils of the old man, senior. By seeing that fragrance of the old book, he immediately regained his consciousness and was ready to argue them. You should love the books because our Bhagavad Gita says, Nahi jnanena sadrusham pavitra vidyate. There is nothing as sacred as knowledge. Knowledge. Knowledge is power, not just information. Therefore, if you read all the papers, write your pleadings properly, stitch the paper book excellently, beautifully, judge whether he is impressed by your writing or not, will be impressed by the stitches, and he may grant entry motor also.
Sir, with your Lordship's permission, one more question.
Yeah.
As a young lawyer, when we are talking about courage, craft and contention, 3C, 3A comes to mind, that is attention, appreciation and approval. Sometimes, my lord, if that is not there, how to deal with it, and what is the importance of 3A vis-a-vis 3C?
3 A's are hidden in 3 C's. A comes first, then B, then C, even in alphabets. Human beings, Aristotle said, we are social beings, social animals. We socialize, we live in group. Those who live away from the group on the mountain, they will not survive for long. That's the report of anthropologists like McIver and Page in Amala Kamala case. Our brain is genetically wired in such a way that we have to live in the company. We have to live in the company, not crowd. It was Shakespeare who said, one is lonely, 2 is company, 3 is crowd. Choose the best company for exchange of ideas, and one will appreciate, because we have a tendency to seek sanction from the peers. We want approval, we want encomia. That is their human nature, it is. But it is up to one particular point. You need, when judge praises you, that's a great. That's great. When parents, when teachers, they praise. Individual feels very happy. But if you depend upon that praise again and again, who will go on praising you? But do your work like ants will do. Like ants will do. Do your work with absolute commitment, keeping minute details in mind. We had one poem when I was in high school. That was an author I do not know, because it was decades ago. Memory is fading. That was like this, I remember. I think Benjamin Franklin. Now I recall. Benjamin Franklin's poem, very simple poem. For want of a horseshoe, the horse was lost. For want of a horse, a soldier was lost. For want of a soldier, the battle was lost. It begins with, for want of a nail, horseshoe was lost. For want of a horseshoe, a horse was lost. For want of a horse, a soldier was lost. And for want of all these things, the battle was lost. A nail is important. So give full concentration when you do your job. Automatically, whether others appreciate or not, you are bound to grow. We are bound to grow. I was reading the history of Dharma Shastras years ago by P.V. Kane, Purushottam Vamana Kane, Pandurang Vamana Kane, Bharataratna Vijeta. He has referred to about 3,000 books in his 2 volumes. Now it is 7 volumes. In thousands of volumes, other books which he has referred to, the names of the author do not figure at all. author's name is not written on the books because the authors did not want any appreciation. So when you want to accomplish great things, do not see back and forth. Concentrate on that. Like Arjuna did in Mahabharata. Only the eye of the sparrow and nothing else. Then you will not go for appreciation and for. If you get it, it's a bonus.
One question is coming in my mind. How does a junior lawyer respectfully stand in the grounds when a judge is hostile or unfairly biased against his client?
Sir, it is
First fault line is that judge is hostile to you. Why do you assume so? A judge has no stake in the matter unless he is bribed in it or influenced. In how many cases bribery or influence takes place? 1 in 1,000? I don't rule out because Justice Bharuka said 20% of the judiciary is corrupt. In 2000, he said it when commemorating 50 years of the Supreme Court. It's on record. Justice Bharucha, S.P. Bharucha, he had said that. By human nature, there are frailties and judges are not an exception to that. But assuming that every judge is your enemy is too much. Still, there may be cases which give an impression that judge is against you, not personally, because he is pro-woman judge, pro-landlord judge, pro-tenant judge, pro-taxpayers judge. This pro is there. Therefore, Cardozo, in his famous book, The Nature of the Judicial Process, he writes, judges make decisions at the rock bottom of the mind, and therefore, that you have to keep in your mind. If judge is little hostile, you should assess. Therefore, it was said, first you should study the judges. This judge operates on which spectrum of the line, whether this side or that side. You will sit in the court hall. Great lawyers used to sit in the court hall. They used to study the psychology of the judge. In tax matter, how this judge operates, how he interacts with the best doctrines, maxims, literary pieces, the great writings of the juries, how he sees the decisions of the Supreme Court, the decisions of the foreign courts. What kind of mind this judge has got? Is he a die-hard judge? Or a judge of wooden head, nothing enters? You have to adjust that. Therefore, you are the first judge. You should judge the judges. There is one such book by Richard A. Posner, who was judge for 36 years in America. He has written How Judges Judge. If you read that, you will have many points with which you can face the judge. The best way is, my lord, I am not well today. And extreme cases, my lord, Adam and Eve are dead. So kindly, there is a bereavement in the family. Give some time. You can have change of the bench or change of the mind of the judge.
Sir, all we want is that, you told that some are pro-taxation, some are pro-women-centric, but we want from the bar that the judge has to be pro-bar.
Which bar?
So this bar. Not that bar, sir. This bar.
That bar is also also not foreign to any judge. There is one poem by John Keats. When Daftari was arguing a prohibition case before the Supreme Court, I don't remember, Bombay Prohibition Act during Morarji Desai's time, the whole entire state of Bombay, then Balsara was the state of Bombay, yes, I remember. The two judges who were hearing had never touched the bottle at all, Puritans. Then Daftari said, my lord, never you have tasted the red wine, and you are going to decide the fate of my client. Kindly do not decide. Give it to some judges who have rarely visited the bar, and that the bar. There is one poem by John Keats. Give me woman, wine and snuff, till I cry old enough. You may do so, sense objection, till the final cry comes from the heaven. He was a celebrity. He died at the age of 26 years because of pneumonia. Therefore, there is nothing like a pro-lawyer judge, pro-farmer judge, pro this judge, pro that judge. There is nothing like that. That being said, judges also have the idiosyncrasies. We have a share of our idiosyncrasies. So if you bring your case within our prejudices, you will be the gainer, or you may be the other side of the gain also. We do not know. You have to study. Great lawyers used to sit in the court hall. They used to judge the judges. How judge? This judge likes language. This judge likes jurisprudence. This judge is bit pro-tenant. This judge is, for example, Justice O. Chidappareddy. He was considered to be a hardcore sociologist. He was considered that way. Even that impression, loose impression you will gather if you read his autobiography, the famous autobiography, I forgot its title, maybe Pranav will be knowing that title, I do not know. Constitution, courts and the Constitution. Courts and the Constitution. We get that. Krishna was very, very pro-labor. All labor unions used to get the cases posted. But they could not fight the battle against the capital. It is capital, which Karl Marx says, ultimately it is capital which rules the people. Capital is the capital of kingdom. Therefore, you can study that also. Then you can argue. Nowadays, there are computers. In America, I was reading Cushman's Court Watchers. She said, in America, suppose about 36,000 cases I have decided in my tenure. If you put all these cases to the computer and say, my case facts are like this, what kind of decision this judge is likely to take? The computer will analyze all 36,000 cases and form an opinion what are the idiosyncrasies of this judge. Whether he is likely to grant interim order of stay, whether likely to dismiss, likely to allow, even this it will say. We can make use of that also.
May I ask a question? My question was related to craft and contention, Your Lordship. So, question was like how to maintain clarity of thought and precision of language in a highly contentious case.
Yes. There is one book by Upendra Bakshi, Courage, Craft and Contention. Name of the book is Courage, Craft and Contention. Advocacy, 7 lamps of advocacy. If you see that, the language is the first point. Pakiwala had a great language. He used to argue the matter so effectively, the judges will whisper to each other on the bench. Now we have been swayed away by the beauty of his presentation. but truth may be elsewhere, we do not know. We will adjourn this matter for 15 days. Or we will hear this and will not give judgment for 1 month. All this effect of Balkiwala should go out. Then we can fairly decide the matter. That Shakti, the language, the felicity of expression, as you have seen Julius Caesar of Shakespeare, where Antonio makes such a great speech that people turned against the assassins, the Brutus, Casca, all these people who had killed Julius Caesar. The entire mass of the people turned against these people in favor of Julius Caesar. That is the beauty of language. That is the beauty of expression. That the lawyers should have. They should have beauty of language. Articulation. What is the point involved? You should articulate. You should, always in the course I used to keep telling the youngsters, have you brought your palm cheat? Entire case should be in palm. Just turning like this. It should remind you everything. Yes, sir, Pranav. Take this one. Yeah.
Respected my Lord, today we have celebrated the Young Advocates Day. I am posing a question to my Lord's permission. If a young lawyer argue a case, he is nicely prepared a case, but Honorable Judge not satisfied his arguments and dismiss this case, he will be discouraged or not?
You file appeal against that.
Yes, absolutely. But
You have one more case.
But my question is,
No, you suppose, see, a judge has no option than to decide the case this way or that way.
yes, my Lord.
If we are to decide the cases this way, and all lawyers become my opponents, how I should
No,
say?
my Lord, my question is, a young lawyer.
That happens merely because he is young. We cannot be lenient. We have to decide the cause according to law, not according upon the age of the lawyer who is arguing. He may be young, old, etc.
He is old man.
We have to see that. We have to see that.
Thank you very much.
Yes.
Sir, beauty of language and if both are the process of craft.
Everything. Ultimately,
Technique
beauty
of
rules.
argument. Technique of argument, beauty of language.
The beauty of everything, your conduct, your demeanor, everything. You see some episodes in National Geographic, in the life of, there is one story, life of fishes. Fishes means fishes. I was seeing that. There was a very thick female fish that was being chased by many male fishes. From other side, very beautiful fishes came, and they left this female fish, went in search of that. Even in the animal kingdom, the sense of beauty operates. There's a famous book on that by Dr. S.L. Mirappa, Satya Mattu Saundarya. It's a PhD thesis. Truth and Beauty is the book. You can look into that.
Sir, my question is,
One.
while arguing a case, what should not be argued at all? I mean, do's and don'ts of arguments.
Yes.
Thank you.
Mr. Nariman in his Before the Memory Fades, he has written that book. He has said, a lawyer should know what to argue, what not to argue, before which judge. Some judges want lengthy arguments. Some judges want short arguments. It all depends, very personal to the court and to the arguing counsel. There cannot be a thumb rule like this only. But he used to, Nariman quotes Sir Alladi Krishna Swami Iyer and says, most of the cases succeed or they are dismissed on their own strength. 25% of the cases are won because of the best performance of the lawyers, and remaining 25% are lost because of overperformance. This is very important. You should know where to stop the argument, because this is not the last case that you are arguing before the court. Balkiwala lost most of his cases during the first 15 years. First 15 years, he lost most of the cases. It's only thereafter, at one point of time, he wanted to quit the profession. He told Sir Jamshedji Khanga, no, this is not my cup of tea. He wanted to quit and he wanted to become a teacher. Unfortunately, the competitor lady scored 1 mark more than Balkiwala. Therefore, Balkiwala's candidature was rejected. That lady came to be appointed as a teacher. And our Balkiwala is former that way.
Thank you so much.
Lordship, question.
Yes, Mr.
Lordship, on behalf of the members of the bar, we are very much highly obliged to have you on this platform. I have a few questions on my mind.
One question. You have to leave the judge to prepare for tomorrow's cases.
Lordship, how does a young lawyer would be able to inculcate self-discipline in his personal as well as in professional life? Second question is, what are the qualities a young lawyer should have to get away with the social media distractions and make it a habit of reading? And third thing is that how a young lawyer would pursue his journey from a transition from being a very good counsel to become a judge.
This I have to tell you some other day. Best books are there. There are best books like 7 Lamps of Advocacy, The Art of Lying, number 2, The Art of Argument by Gerald, number 3. Art of Argument, many books are there. That one has to read. Nothing comes free. Nothing comes free. One has to strive for that. You ask Monkey how long he has strived to know the service law and labor law. He will tell you, Monkey is not made in a day. G is not made in a day. Panda is not made in a day. They burn midnight oil. Then it happens. So, very difficult to answer these questions in a session like this. That too when we are at the fag end and the compere is standing there to put an end to all this.
Thank you all for engaging those questions and such insightful answers. Swami Vivekananda believed in encouraging the youth to build a stronger nation. In that spirit, the Adhivakta Parishad and the High Court Bar Association wish to recognize and encourage the promising talent within our fraternity. We will now proceed with the felicitation of young advocates. I request the dignitaries on the dais to kindly do the honors. Now I request Mr. Thakur Sangram Singh. Now I request Ms. Shweta Senapati.
You should become Senapati of the bar.
Look.
This also.
Now I request Milan Kumar. I will request Ms. Aishwarya Das. I will request Aditya Chandan Linka to come to the dais.
Mr. Venkat, are you related to Lekka? No.
Now I also request Mr. Parishad Gar, Senior Advocate, President of Adhivakta Parishad, Odisha High Court Bar Association, and Manoj Mishra, Senior Advocate, President of Odisha High Court Bar Association, to felicitate our chief guest, Mr. Justice Dixit Krishna.
Thank you, sir.
I will request Mr. Jatteswar Naik, Secretary Adhivakta Parishad, to felicitate Senior Advocate Manoj Mishra, President of the Odisha High Court Bar Association. I will request Mr. Abhijit Patnaik, Secretary Odisha High Court Bar Association, to felicitate Mr. Uttar Prasad Kara, Senior Advocate, President Adhivakta Parishad, High Court Bar Association. Now I invite a man known for his astute legal acumen, Sri Manoj Kumar Mishra, Senior Advocate and President of Odisha High Court Bar Association, to address the gathering.
Mr. Shripad, my learned younger brother, Mr. Kar, Senior Advocate, Secretary Abhijit Patnaik, and my younger brother, Mr. Jatteswar Naik, my friends here. There is no space for me to speak anything, and there is no time also. After my Lord Justice Shripad's speech, actually there is nothing left in it. I was thinking of giving one example, but time will not permit me to give that example. That example, if you permit me, then I will give one example. That's because courage, conviction, and conviction and craft also. If you could only, it will take only 2 minutes. If my Lord Justice B.L. Lakshare was our Chief Justice. He was a very dynamic judge and very accommodative to the young lawyers and very encouraging he was encouraging the young lawyers like anything. A particular case came to my office that the name was Raghunath Dwivedi. Raghunath Dwivedi was a school inspector, district inspector of schools. He was convicted in a criminal contempt proceeding. He was sentenced to undergo 1 month arrest, 1 month SI. So what happened is he had traveled almost all stalwarts, all senior lawyers and stalwarts. They all said that you preferred appeal under Section 19 to Supreme Court. But he had no scope to, there was no means to go to Supreme Court. So anyhow, somebody recommended my name. I was only 11 years of practice at that point of time. So when he came to me, I said that nothing can be done by me. But anyhow, because my seniors have said that one midnight trial, so I read. Read and I spent more than 15 days to reading the Article 15 the Constitution of India and all the judgments of the Supreme Court as well as the parliamentary discussions and all that. Thereafter I mustered a courage to draft a petition to recall that judgment. Then I filed that. Then again I read. Then I filed that petition. When that judgment matter was listed before the Honorable Justice Hon'ble, when he came to the court with the angry face, he was said, "Is that Mr. Mishra? I had a very good impression on you because you have been arguing your class cases are arguing very well, but I had a very good impression on me. But yesterday night when I read your brief, I was shattered. My impression is shattered." But then there the courage came. Because I had read and I had convinced that I have got a good case. So I said, my lords, we have been taught to read again and again and for midnight trial, for we bonds together. So I read this particular law for 15 nights. And thereafter I mustered some courage to draft the petition. Again after drafting the petition, I again read it for 100 times. Thereafter I mustered the courage to file the petition. Thereafter he said that, then he always understood that certainly Mr. Mishra will not speak anything wrong. So he said, okay, argue. And the argument started at 11:15 and ended in 3:45 p.m. And all the judgments, all the interpretation of Article 215 was totally placed before the Honorable Chief Justice. His Lordship was sitting with the Honorable Justice cases and I will no more with us. That's my Lord Justice is also no more with us. Thereafter, when Mr. R.K. Patra was the counsel, Justice, his Lordship was later elevated as the Judge of the High Court and Judicial Sikkim High Court. My Lord, then next day, my Lord Justice R.K. Patra, as his Lordship there was, argued the matter. After 7 days, the judgment came. And we know what is the first sentence in the judgment. Of course, in that judgment, I am not able to get it in the record. That I deal now because I was under the impression that I know much about the Constitution. Because I have written a book on the Constitution. But a young lawyer opened my eyes and said that what can be interpretation of the Article 215 of the Constitution and also what can be the effect of the law. And thereafter, he not only recalled that judgment, but also held that recall petition maintainable and recalled that judgment. So that sentence itself, because I had read, I had the courage to argue. Because I had read and then I had the confidence to argue. And because I had read, because I had the contention, I had acquired the skill of arguing before my Lord Justice Australia. So this is the only example which I can say that all young lawyers should do that. Because as my Lord Justice Shripad said, read and read and read. After reading only can all these answers, all these aspects will be answered by acquiring knowledge only. Merely because one case is against you, that doesn't mean that you are, because that judgment, maybe you may utilize that judgment at a later stage in some other case. The lawyer never either wins or loses. It is the client who wins or loses. So you only get a law to be decided. If the law is decided, that law will be utilized by you in another case. Though that law was enacted, that law was decided against you, but that law will be utilized by you in some other case. Besides that, I should not speak anything more. And we are really thankful to my Lord Justice Shripad because of his Lordship's brilliant speech and also the articulation and everything. Another thing I want to announce is that my Lord Justice Shripad, when I was in his Lordship's court, is that Mr. Mishra, I have got 500 bands to be distributed to young lawyers. So you please. So today the bands have been distributed to by young lawyers who are felicited. They are the bands gifted by my Lord Justice Shripad. So it is, we are really obliged and thankful to his Lordship for thinking about the young lawyers, not only that, thinking about the young lawyers and gifting the band. Through this, his Lordship's blessings are there on you. So we will be distributing those bands even here also. At least since his Lordship has already distributed some bands the lawyers who are felicited, but now we'll be distributing those pants to young lawyers here, and thereafter whatever will be left will be distributed later on tomorrow, day after tomorrow is gone. Thank you all.
All good things must come to a conclusion, but the inspiration we take from here is everlasting. To propose a vote of thanks, I invite Dr. Naik, Secretary, Adhivakta Parishad, Odisha High Court, to deliver vote of thanks.
Jai Jagannath. As a Secretary of Adhivakta Parishad, Odisha High Court Unit, I have been assigned to make the vote of thanks for this event. Respected Chief Guest, Honorable Justice Dixit, Shri Krishna, Honorable Judge, Odisha High Court, Shri Manoj Kumar Mishra, Senior Advocate, President of Odisha High Court Bar Association, Shri Rudra Prasad Kara, Senior Advocate and President Adhivakta Parishad High Court Unit, Shri Abhijit Patnaik, Secretary High Court Bar Association, esteemed guests, fellow advocate and dear participants. It is my privilege and honor as a Secretary of the Adhivakta Parishad High Court Unit to extend our heartfelt gratitude to all who have contributed to the success of this symposium on young advocate and advocacy, courage, craft and connection. First and foremost, I wish to express profound thanks to our Chief Guest and erudite speaker and most lovable and popular judge of the Odisha High Court. And I can say, my lordship is the judge of this bar. I can say, Honorable Justice Dixit, Krishna Shripad, for sparing valuable time for judicial duty to inspire and enlighten us with a thought-provoking address. Your insight into the advocacy, courage, craft, contents for young advocate will act as a guiding light for all. I also thank Shri Manoj Kumar Mishra, Senior Advocate, President High Court Bar Association, for sharing his vision and leadership. And I say thanks to Shri Rudra Prasad Kara, President of High Court Unit, Adhivakta Parishad, for the warm welcome and tireless support in organization in this event. And I also thank Shri Abhijit Patnaik, Secretary High Court Bar Association, deserve thanks to cooperate us to a success to the symposium, as well as thanks to our institution to provide this conference hall. We are grateful to all speakers, moderators and participants who enriched today's discussion and to organize team for their meticulous planning and execution of the agenda, for escorting our guests. All guests and advocates present, your inclusive and thoughtful questions have made this symposium dynamic and meaningful. We thank you for your active participation and respective new ideas. Most importantly, I extend my thanks to the young advocates who have been felicitated today with a hope that they will keep up the hard work and uphold the institution values. And I thank the learned senior advocate, law student, print media personnel and support staff, including police and others, for their supporting and help this event. Finally, I extend thanks to every member of High Court Bar Association and member of Adhivakta Parishad, support staff and volunteers whose dedication and teamwork have shaped the program into the memorable event. Thank Bharat Mata ki Jai, Jai Jagannath.
Thank you all for joining us on this significant occasion. Now I request everyone to stand up for national anthem.
गण अधिनायक जय भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल गंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तब शुभ नामे जागे तब शुभ आशीष मांगे, गाहे तब जय गाथा। जन गण मंगल दायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
चलो